let's get into that part of the discussion here. Bruen's happened last June. It's not that long ago, right? Especially in constitutional law terms, right? But there's been quite a lot of development to this point. Where do you see things as of today in terms of how federal law has changed as a result of Bruen?
Well, I think the Second Amendment movement is doing extraordinarily well in the courts. You have to keep in mind, Steve, that Heller versus the District of Columbia was decided in 2008. From 2008 to 2022, you had really a rebellion among federal judges in many parts of the country to try to ignore and pretend that Heller didn't exist and try to find excuses to ignore our fundamental right to keep and bear arms. But since Bruen, we have literally won more Second Amendment cases by orders of magnitude in the last 7 or 8 months since June of 2022 than we had done so in the prior 10 plus years. And I think that alone tells you a couple of different things. First of all, it tells you just how powerful the sort of analytic methodology of Nysurpa versus Bruen was. Because when you do high-end constitutional litigation, Steve, it's not just who wins the case. Of course, who wins the case is very important. But equally important is how they win the case, the methodology that gets applied, because the Supreme Court only takes about 80 cases a year. So when they decide a case, it's not just about who's the winner, who's the loser. It's also about what is the teaching tool, the methodology, the legal approach that they're trying to teach the lower courts what they should be doing going forward in similar cases. And with Nysurpa versus Bruen, by saying to the lower courts, look, the founding fathers told us that the balancing of interest between the good of guns and the bad of guns to the extent that exists has already been done for Americans in the form of the Second Amendment. That was the outcome of a balancing set of interests by our founding fathers, balancing, the government authority and power on the one hand against individual freedom on the other hand. And that gave rise to the text of the Second Amendment. And now the Supreme Court says going forward, we want text and history and not balancing tests going forward. And that's made a big difference, Steve.
Yeah, I think that's a really important point about Bruen itself that gets overlooked a lot. Thomas talks exactly about this, about how the Second Amendment itself is the result of a balancing test. And so taking that and then applying a balancing test on top of it doesn't make any sense from his point of view, right? And it's something I think gets lost a lot in discussion of Bruen, right? You focus on the text and tradition aspect of it, because that's how you practically go about making a decision under the standard. But why they went with that often gets ignored when people talk about Bruen. And I think that's a really key point here. The balancing test. Americans have, through having a Second Amendment in the first place, has already determined that gun ownership in society is valuable and outweighs the negatives that come along with it, right, as on a whole.
Absolutely. In fact, Justice Scalia said this exact same thing in Heller. He specifically said at the end, as you know, Stephen, he said, look, the founding fathers did this. So, coming to court to talk to judges about the application of the rule of law to a particular case should not involve balancing of interest as a matter of public policy. Public policy decisions are made at the constitutional level by guess whom? We, the people. The American people enacted the United States Constitution. It's been amended, by the way, 26 times. So it's not like you can't change it if you want to. But of course, the left wing in America, Steve, wants to change the Constitution the way they want it to go through using unelected judges. That's been their modus operandi from the beginning. They don't like to go through the constitutional amendment process to speak to we the people. They would rather have unelected bureaucrats, unelected judges make those modifications to the Constitution, because frankly, it's a lot easier to do so, but that's not how our system is supposed to work.